Friends, this video is on parliamentary privileges, and for the sake of convenience, I have divided the presentation into two parts. This video will deal with part 1, and this part 1 will deal with various privileges of members of parliament, and in the second part I will deal with the conflict between fundamental rights and parliamentary privileges and the judicial approach thereon. In India, the parliament is considered as the center of power and is the supreme law-making body. It scrutinizes the functioning of the executive and holds it accountable for its decisions. The government is collectively responsible to Parliament for its actions. In order to enable the Parliament to discharge its functions without any hindrance, certain rights and immunities which are not available to common citizens have been provided to members of Parliament, both collectively and individually. These are known as parliamentary privileges. These privileges are borrowed from Britain and they are adopted in the Indian Constitution by Article 105. Similar privileges are provided by Article 194 for state legislative houses. Article 105 defines the privileges of the two houses of Parliament. This provision does not exhaustively enumerate the privileges. It specifically defines only a few privileges, but for the rest, it assimilates the position of a house to that of the House of Commons in England. Thus, the parliamentary privileges can be put into two categories. One, those who are specifically mentioned in the Constitution, and secondly, those which have been held to have been granted because similar privileges are available in England. Let me first deal with the privileges granted specifically by the Constitution. The first privilege that is specifically provided is the freedom of speech of the members. As we all know, the essence of parliamentary democracy is a free, frank and fearless discussion. Thus, most important of parliamentary privileges is that of freedom of speech available to members while performing parliamentary duties. Article 105 Clause 1 expressly safeguards freedom of speech in Parliament. It says that there shall be freedom of speech in Parliament. No action, civil or criminal, will therefore lie against a member for defamation or the like in respect of things said in Parliament or its committees. The immunity is not limited to mere spoken words. It extends to votes, as Clause 2 of Article 105 specifically declares that any vote given by him in Parliament or any committee thereof. However, this freedom is subject to other provisions of the Constitution and to the rules and standing orders regulating the procedure of Parliament. So read, freedom of speech in Parliament becomes subject to the provisions of the Constitution relating to the procedures of Parliament, that is Article 107 and 121. Thus, for example, freedom of speech in Parliament would not permit a member to discuss the conduct of any judge of the Supreme Court or of a High Court. Likewise, the freedom of speech is subject to the rules of procedures of a House, such as the restrictions on use of parliamentary language or unparliamentary conduct. The freedom of speech guaranteed under Clause 1 is different from and wider than that of which a citizen enjoys as a fundamental right under Article 19(1)(a). The freedom of speech as a fundamental right does not protect an individual absolutely for what he says. The right is subject to reasonable restrictions under Clause 2 of Article 19. The term freedom of speech as used in this article means that no member of Parliament shall be liable to any proceeding, civil or criminal, as I have already mentioned earlier. In P.V. Narasimha versus State has held, the Supreme Court has held that the privilege of immunity from courts proceedings in Articles 105 Clause 2 extends even to bribes taken by the members of Parliament for the purpose of voting in a particular manner in a parliament. The court was, however, unanimous that the members of parliament who gave bribes or who took bribes but did not participate in the voting could not claim immunity from court proceedings under Article 105, Clause 2. This decision has been severely criticized, and in my next video I am going to deal with this case in detail. Besides the freedom of speech to which Article 105, 1 and 2 refer, would be available to a member of parliament only when he attends the session of parliament. Therefore, if an order of detention validly prevents a member from attending a session of parliament, no complaint can be made that the said right has been invalidly invaded. The second specific right that is guaranteed under Article 105 is the publication of proceedings under parliamentary authority, provided by Articles 105, Clause 2 and 361A. Clause 2 of Article 105 expressly declares that no person shall be liable in respect of the publication by or under the authority of either House of Parliament of any report, paper, votes or proceedings. In J.C. Ghosh versus H.S. Mukherjee, the Supreme Court held that this protection did not extend to the publication made by a private person without the authority of the House. However, the Constitution 44th Amendment Act of 1978 has put the immunity of publication for publication on a very sound footing. It has added Article 361A to the Constitution, and this article provides in Clause 1 that no person shall be liable to any proceedings, civil or criminal, in any court in respect of the publication in a newspaper of a substantially true report of any proceedings of either House of Parliament or the Legislative Assembly, or as the case may be, either House of the Legislature of a state, unless the publication is proved to have been made with malice. Let us now deal with the other privileges. Clause 3 of Article 105, as amended, states that in other respects, the privileges of each House of Parliament, its members and committees shall be such as defined by law enacted by Parliament, and until Parliament does so, which it has not yet done, shall be such as exists on 28th June 1979, that is on the date of commencement of Section 15 of the 44th Amendment Act of 1978. Before the amendment, this clause had provided that until Parliament legislates, the privileges of each House and its members shall be such as those of the House of Commons in England at the time of commencement of the Constitution. As the position till 20th June 1979 was determined on the basis of the original provision, it is still relevant to refer to the law as it has evolved in Britain. Thus, the following privileges of House of Commons, not specifically mentioned in the Constitution, are available to the members of Parliament in India. They are: the first one is the freedom from arrest. According to this privilege, no member of Parliament or a state legislature shall be arrested or imprisonment in a civil proceeding during a period of 40 days before and 40 days after the session of the House. If a member is arrested within this period, he shall be released so that he may be free to attend the session. This privilege does not extend to arrests or imprisonment on a criminal charge or a contempt of court or to preventive detention. However, in case a member is so arrested, Rule 261 of the Lok Sabha lays down a duty of the detaining authority to communicate to the House to which member belongs the reasons for arrest or detention, the time of arrest, the place where he is detained or imprisoned, and the period for which the member is detained or arrested. The next right is right to exclude strangers. The Houses of the Parliament have the right to exclude strangers or non-members and to hold secret sessions. Rule 248 of the Lok Sabha gives the chair to the power to the chair, and the chair, whenever it thinks fit, of ordering the withdrawal of strangers from any part of the house, and when the house sits in a secret session, no stranger is permitted to be present in the chamber, lobby, or galleries. The only exceptions are the members of the Council of States and the persons authorized by the Speaker. Next right is right to prohibit the publication of proceedings. The rules of procedure of the Lok Sabha empower the chair to expunge any part of the proceedings of the House. In Pandit M.S.M. Sharma versus Sri Krishna Sinha, popularly known as Searchlight case, proceedings for the breach of privilege had been started against an editor of a newspaper for publishing those parts of the speech of a member delivered in Bihar Legislative Assembly which the Speaker had ordered to be expunged from the proceedings of the Assembly. The editor in a writ petition under Article 32 contended that the House of Commons had no privilege to prohibit either the publication of publicly seen and heard proceedings that took place in the House or that part of the proceedings which had been directed to be expunged. The Supreme Court, by a majority of 4-1, rejected the contention of the petitioner. The next right is right to regulate internal proceedings. The House has the exclusive right to regulate its own internal proceedings. The procedure is laid down in the rules of business of the House. To strengthen this right, Article 122 expressly provides that the validity of any proceeding shall not be called in question on the ground of any alleged irregularity of procedure, and no officer or member of Parliament in whom powers are vested by or under the Constitution for regulating the procedure or the conduct of business or for maintaining order in Parliament shall be subject to the jurisdiction of any court in respect of the exercise by him of those powers. The next right is right to punish for contempt of the House. It can be emphatically said that this power could be considered as the core of all privileges because it provides teeth to them. Every house of the legislature has the right to punish its members or non-members for contempt or breach of privilege of the House. It can be said that what hinders or obstructs the smooth functioning of the House or misleads the House by giving false information or which undermines the prestige of the House or lowers people's faith in the House, it can be said to amount to contempt of the House. After coming to power in 1977 elections, the Janata Party moved a resolution in the Lok Sabha that Mrs. Gandhi, the former Prime Minister, had committed a breach of privilege, contempt of the House by causing obstruction, intimidation, harassment, and institution of false cases against 4 officers who were deputed to collect information relating to Maruti Udyog Limited, installing imported machinery in violation of license regulations. The Privileges Committee was constituted to inquire into the allegation. The committee found that Mrs. Indira Gandhi guilty of committing the breach of privilege by preventing Parliament from knowing the violation of license regulations by the Maruti Udyog Limited. She committed a further breach of privilege and contempt of the House by refusing to take oath or affirmation before the Privileges Committee and by casting aspersions on its members. Accordingly, she was held guilty and was expelled from the membership of the Lok Sabha and sentenced to jail till the House was prorogued. She accepted the sentence. However, when in 1980 elections the Congress party came to power defeating the Janata Party, a resolution got passed in the Lok Sabha rescinding the earlier resolution, and it was held that she did not commit any contempt of the Parliament and that the resolution was politically motivated. With this, I conclude this presentation, and as I have already told you, in the second part, I am going to discuss the interface between fundamental rights and parliamentary privileges and the judicial approach towards that interface. With this, I conclude. Thank you for your patient listening.